My name is Gerald Groff. I'm an evangelical Christian who believes that Sundays should be devoted to worship and rest. In 2012, I began delivering mail for the United States Postal Service. When my position began requiring me to work on Sundays, I transferred facilities, but was soon forced to work on Sundays again. I received progressive discipline for failing to show up for work until I resigned. This failure to accommodate my religious practices is unlawful under Title VII of the Civil Rights Act of 1964, which requires employers to accommodate their employees' religious practices, unless doing so would impose an undue hardship on the conduct of the employer's business. The Supreme Court's decision in Trans World Airlines Incorporated v. Hardison has been interpreted to mean that an undue hardship is anything more than a de minimis or trivial cost. I believe Hardison should be overturned, and the phrase undue hardship should be interpreted to mean significant difficulty or expense to the employer.
My name is Louis DeJoy. I am the Postmaster General of the United States. Mr. Groff, I agree that an undue hardship is not simply anything more than a de minimis cost to the employer's business. An undue hardship is a substantial cost to the business, such as the cost of regularly operating short-handed or paying premium wages to substitute workers. However, we should not overturn this court's decision in Hardison, but rather clarify its scope.
Well, under either of our definitions, USPS has failed to show that accommodating my religious practice would cause an undue hardship. Reasonable accommodations such as scheduling another mail carrier to work on Sunday would accommodate me without any cost. I grant that some of my coworkers may be upset at having to work on Sunday when I can stay home, but that does not constitute an undue hardship on USPS's business.
I disagree. Your refusal to work on Sundays did impose an undue hardship on USPS. Never scheduling you on Sundays violated the company's Memorandum of Understanding, forced your station's postmaster to deliver mail in violation of a collective bargaining agreement, and increased the workload for other employees so much that 2 carriers left the station.
Well, let's hear what the court has to say.
Great idea. The question we will rule on today is whether this court should disapprove the more than de minimis cost test, stated in Trans World Airlines Incorporated v. Hardison for refusing Title VII religious accommodations. And our answer is
yes.
We concur.
So, who wins?
Let me explain. We believe that we should clarify our decision in Hardison rather than overturning it. Lower courts have improperly interpreted Hardison by putting too much weight on the de minimis test. Both Mr. Groff and Mr. DeJoy agree that this test is incorrect, but they differ in the alternative language they would like to see used. We believe that, in order to avoid accommodating an employee's religious practice, an employer must show substantial increased costs in relation to the conduct of its particular business. This is because Hardison itself repeatedly referred to substantial burdens, and the ordinary meaning of undue hardship suggests an excessive or unjustifiable burden, not a burden that is merely more than de minimis.
So, I win, right?
Well, this heightened standard of review does place more of a burden on USPS to prove that they cannot provide your religious accommodations without undue hardship. But courts must apply the undue hardship test on a case-by-case basis, taking into account all relevant factors, including the particular accommodations requested and the nature, size, and operating cost of the employer.
Yes, I agree that this court should not overrule Hardison because stare decisis has enhanced force in statutory cases like this one. Congress has had multiple opportunities to reverse Hardison and has not done so. We should respect the wishes of Congress. I also want to clarify that undue hardship may include a burden on a business's employees when the business's conduct is affected.
Okay, so basically, the undue hardship test must be applied on a case-by-case basis. And in this case, I win, right?
Well, we will leave it to the lower courts to apply our clarified context-specific standard. The judgment of the Court of Appeals is vacated, and the case is remanded for further proceedings consistent with this opinion.
So, we just have to wait and see.
Gee, thanks, Supreme Court.